The 1976 Copyright Act outlines in detail the statutory rights that come with having a copyrighted work. Generally, the copyright owner has the exclusive rights to do or authorize the following: reproduce the copyrighted work, prepare derivatives or adaptation works of the copyrighted work, distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending, perform the copyrighted work publicly, public performance, display the copyrighted work publicly, public display right. And you can find that in the Act at 17 U.S.C. 106. The point is that these are the exclusive rights. A copyright owner does not have unlimited ownership of the copyright work. He or she has this set of exclusive rights. People can do all sorts of things with the work that the owner may not like. It is only if someone's actions fall within one of these exclusive rights, that there's a copyright infringement. Now, with that said, each exclusive right has its own rules specific to it based on the definitions in the Act. The exclusive rights are subject to a number of limitations as well, and we'll discuss those. So we're going to start with the first one, reproduction. Copyright takes its name from this exclusive right, the right to make copies of the copyrighted work. And the Act actually has a definition. Copies are defined as material objects other than phonorecords in which a work is fixed by any method now known or later developed, and from which the work can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or device. So let's break it down. Fixed, right? It has to be in something. Fixed tangible medium, paper to vinyl, vinyl to DVD, maybe nice sculpture, has to be fixed in something. This copy has to be fixed on something. Method, a method that we know now, writing something down on paper, typing it into the computer, putting it on an MP3 file. And obviously the Act in 1976 thought that there would be future technologies as well to make copies, and they cover that by saying, and future technologies that might be later developed or known. You can use and you can use this for various purposes or forms. So novel, recording an audiobook, putting something in Kindle format. And the work has to be observed. You have to be able to observe this copy, I should say. You have to be able to observe the copy, either directly. Oh, I wrote it down, I could see it. There's a painting hanging on the wall. The copy is a painting. Or you have to use a device. So if I have something on a DVD, I got to put it on something. If it's a movie, I have to put it on something. I know movies nowadays can be streamed. We're going to talk about digital in a little bit. But for example, Klink put together an abstract sculpture out of large steel beams. So anyone who copies that same abstract sculpture would be infringing. Possible examples of this: another sculpture that copied her work into a similar outsized steel work. That's obvious, right? Another sculptor made a tiny version out of toothpicks. That's another way of copying. An artist detailed a drawing of the sculpture. A photographer shot a photo of the sculpture. There might be some fair use argument, but we'll talk about fair use later. What we're talking about is making a copy, ways things could be copied. Copy could be in any form. Photograph could be copies on film. You could take photos from a film. Nowadays, you got the paper version. You got negatives in some instances. You got memory of a digital camera. You got a copy on a hard drive. Copy could be in any form. Dylan writes a short story. He would have the rights to make copies in any form. paper, magnetic tape, CD, hard drive, iPod, or app, I guess I should say. If it's audio, it could be iPod. So I ask, can one infringe on another's copyright by making a copy alone in her office? So unlike the other rights that we'll get to, this one is not limited to the public acts. One can infringe by making a copy all by themselves. So let's say I got the newest edition, first edition of Harry Potter, and I don't want to get it all messed up by opening it and crack the binding and keep using it. I want to preserve it and save this one copy. So I am in my office and I make copies of it on my copy machine. Did I infringe on the author's copyright? Yes, I did. I copied it. I don't have to distribute it. I don't need to sell it. I just have to copy it. And I did that. That would be infringement. Making a copy usually means literal, right? Literal copying a newspaper article on a copy machine, copying text or pictures onto a computer. But copying is much broader here in the copyright world. A copy of a work may be any object into which protected elements of the copyright work has been copied. Remember our discussion, idea versus expression? So a writer who paraphrases another novel, or a photographer who closely models her photo on another, could be liable. You saw that in the ideas versus expression and some of those assignments we had to do. This is where, plagiarizing comes in. When you paraphrase another's novel, or writing. Suppose Abel wrote a compelling short story, which Baker made into a novel. The novel would be a copy of the short story. The question that the court looks at is whether the defendant took protected expression or unprotected elements. Again, we've already perused through that, but we're kind of developing on the idea. Partial copies. Suppose author has a copy in a book, has a copyright in a book, and I wanted to copy a chapter, and I do, and I don't ask for permission. Yeah, that's infringement. You could take a quarter of the book. There's a case going on right now where somebody tweeted, and you know how short tweets can be if you're a Twitter person. You can't put an entire novel on Twitter. You probably can't even put an entire page on Twitter. But you can snap maybe a paragraph. And there's currently a court case with regards to infringement. Somebody tweeting a full word-for-word paragraph from I believe it's a short story. And now it's being shared, right? It's being retweeted. So that creates a whole nother issue. So infringement requires only copying some original creative expression from the copyrighted work. Taking a portion of it and copying of it constitutes an infringement on the right of reproduction. We'll get to other ways that could be used, like fair use, but we'll talk about that, and we'll talk about what exactly constitutes infringement when we talk about those kinds of lawsuits. But what we're talking about here is how copying works, the exclusive right of reproduction. So infringement has been found copying a few hundred words of a book to a few seconds of a song. We'll talk about that few seconds of a song when we talk regarding music. Here's another question that comes up. The DRAM, they call it the DRAM issue, is a temporary copy inside a computer, a potentially infringing copy. With digital technology, this broadens the potential of copying because they can easily be copied without what? Losing any quality. When you take something off a disk or you download it, it makes a temporary file on your hard drive. Is that a copy? Whether making a temporary copy within a computer counts as making a copy for copyright purposes is an issue that's still trying to be flushed out in the court system. But some say yes, it is making a copy. The question is whether there's some liability going along with that, and the question that has to be asked is, why is it being copied? So if a temporary copy counts as a copy, then someone could potentially infringe copyright by using a program or even viewing an image that you may already own. Maybe you bought a photo. You still have to, it goes temporarily, copies temporarily made on your computer, a text on computer. So there could be some infringement issues. And it's different from a book or a painting, right? You're reading a book or you're viewing a painting. It doesn't touch, right? It doesn't touch the right of the owner while you're looking at it. You're just looking at it. For electronic digital works, the copyright comes closer to giving exclusive rights to the use. But I'm going a little outside of our bounds here. These are issues to keep in mind. There is no black or white answer to that question. I want to talk about the Cartoon Network case really quick. I actually believe it's in the materials, and what this involves is making a copy. The question is, who made the copy? We're talking about a case involving DVRs, right? In this case, the plaintiff, who is the Cartoon Network, sues CSC Holdings over the operation of DVRs, claiming that it would directly infringe on their exclusive rights to both reproduction, and publicly performed, but we're not talking about that. We're talking about reproduction. And in that case, the court concludes that making a DVR available for, we all know what a DVR is. I guess I should go there first. Yeah, I'm assuming you guys all know what a DVR is, but this gives people the ability to record programming that comes on television, to keep it general and basic. And they're suing the company that allows that puts that service, that DVR service out there, and claiming that they should be liable for infringement because of people making copies of the programming. And the court said, no, to establish that kind of liability on a company, you can't establish that kind of liability on this company because the company isn't the one doing the infringement. It is the customer. So, and they compared it to, there's a huge case that the Supreme Court answered with regards to the VCR. If you remember the VCR, or know of the VCR, the video cassette recorder that initially allowed people to record programming off the TV. And the court said, no, there's legitimate reasons for those types of technology. And while customers might use it to do something illegal, like infringing on copyrights, you can't make the business or the company that brought that service liable for that. That you need some sort of volitional conduct. So let's talk about that for a minute. If you copy someone else's work, there is no need for the copyright owner to show that you intended to infringe or that you had a motive of commercial gain. So this is interesting, right? You don't need intent. It's kind of some sort of strict liability. If you copy someone else's work, there's no need for a copyright owner to show that you intended to do the infringement or that you had a motive for commercial gain, i.e. to make money. But there has to be some showing of a causation or a volition. What does that mean? We already talked about it with the Cartoon Network, but suppose business allows a customer to use one of its copy machines. Unbeknownst to business, the customer uses the machine to make unauthorized copies of various poems. So should we hold the business owner responsible? No, they may own the machine and control it. It hasn't made the copies. So similar to the Cartoon Network case, also internet service providers have been deemed not responsible for the content that the users post on their websites. God, can you imagine all of the lawsuits that can stem from that? But the caveat to that is providing that the ISP did not play an active role in allowing or knowing that the copyrighted infringement was happening. You see this a lot with YouTube and Facebook and the various social media outlets. YouTube now has licensing available. That's through their user service, but we'll talk more about that when we talk about the Digital Millennium Act and how ISP, what their role is in ISPs and what their liability could be on infringement. So right of reproduction. Don't need to show intent, but there has to be some sort of volition. Independent creation is not infringement. What does that mean? If someone makes a similar work without copying from the copyrighted work, there's no infringement. So this is always an area of contention, and we're going to explore this. Independent creation is one of the elements that a plaintiff has to show in an infringement case, along with the substantial similarity. And we'll expand on that test in a couple weeks as well. We're kind of building up to it. So if someone makes a work and it sounds like your work or it looks like your work, but they've created it independently, you're not going to have an infringement. So if a composer writes Ode to Glee and holds a copyright, if composer hears a subsequent composition by someone else that sounds extremely similar, she may have a copyright infringement, but that person is only going to be liable if she copied the composer's work. If she happened to come up with a similar idea, maybe copied elements that were in the public domain, they're not liable. Sound recordings have their own special rules. They have a tailored set of exclusive rules that become more narrow. Sounds are fixed in phonorecords. And phonorecords have their own definition. It's right there. Material objects in which sounds are fixed by any method now known, later developed, and from which the sounds can be retrieved, perceived, reproduced, or otherwise communicated either directly or with the aid of a machine. Sounds are fixed in phonorecords. The copyright owner has the exclusive right to reproduce the work in copies or phonorecords. Again, phonorecords, cassettes, albums, MP3 files, whatever it seems to, whatever the developed method using to fix that in its tangible medium. They have to have literal copying. Okay, this is different than our other works that I just said. You can have a partial and a non-literal copying, and it can still constitute copying. With sound recordings, it has to be a literal copy. The infringing of a sound recording is for the literal copying only. Non-literal copies do not count. You must recapture the actual sounds fixed in the sound recording. Now, I did have an example of this. Yep. Gilbert, for example. Gilbert creatively makes a sound recording of the goings-on in a typical corporate office. If Sullivan gets a hold of the sound recording and copies it into his own sound recording, that's potential infringement. If Sullivan listens to Gilbert's recording and says, I can do that, and then makes his own recording, making the sounds very similar to Gilbert's recording, that is not infringement. He did not capture the actual sounds of Gilbert's recordings. So that's the exception with regards to reproduction and sound recordings. The next right we're going to talk about is derivative or adaptation rights.